Yes. Anyone make a mention? Yes, Mr.
My lord. I have to mention item number 17 and 19, my lord. These two matters, my lord, may I prefer taking after vacation, my lord.
17, 19, third week of January, only date to be fixed. Yes.
May I please, your lordship? Item 52, lordship, pass over for the day. 52. CD available, man.
Have you informed the other side?
Any date next.
Have you informed the other side? Are you on interim
No, no, man.
after vacation? On a date to be fixed. Yes.
May I please, your lordship? I beg to mention for listing, so matter may come up tomorrow.
When did you file?
Friday, my lord.
What is the filing number?
Filing number 11462, 2024.
Okay, if it is not listed tomorrow, you make a mention tomorrow. Okay? First, let us see whether it is listed tomorrow.
May I plead your lordship, item 21 of today's list, your lordship, matter may kindly come up after vacation. In the meantime, FSL may be called for.
FSL not yet received, my lord, yes.
Okay. Okay.
Oblige.
After third week of
FSL will be.
after third week of January.
Look, CD may be written and after that CD may be, we after vacation.
May I please, your lordship? Your lordship, I beg to mention item number 20. The conducting counsel is out of station today, so maybe adjourn any date may be fixed, your lordship. Item number 20.
20.
After vacation.
Much obliged.
On the date.
Please, your lordship, I beg to mention item number 61, my lord.
Yes.
This matter will be adjourned for the day, my lord. We have some difficulties today, my lord.
Do not like that.
This is motion matter, my lord.
Oh.
Keep
Wait
your-
for the date.
My lord, I pray just to list this matter tomorrow, my lord. Urgency is there because the petitioner is a student, my lord, and he has to give the examination. That's why, my
When
lord.
did you file the?
Yesterday only, my lord, but
Hmm.
tomorrow, my lord, kindly, my
You
lord.
have the filing number?
Yes, I have.
What exam is appearing?
My lord, the filing number is double.
What exam the petitioner is appearing? In which
What
exam is
exam?
going to appear?
What?
AB. Oh, yeah, exam, my lord, that is a CAT, this teacher's eligibility test examination.
When it is there? When it is
On
there?
14, my lord.
Okay.
Obliged, my lord.
May I please, your lordship, I beg to mention listing on IA, my lord. Last 4 occasion it was listed but not reached, my lord. For suspension of sentence, my lord. Matter may be taken up next Friday, my lord.
17th, Tuesday.
Obliged.
May I plead your lordship? I beg to mention item number 41. Adjourned for day, lordship, after the vacation, lordship.
CD available.
Are you in interim?
No, lordship.
Third.
Obliged.
Lordship, I beg to mention one BA, lordship, for listing with AB 2734/2024, which is fixed on 12th December, lordship. Same PS case number.
Okay.
Another AB, lordship, AB number 3042/2024, that may be this week, any this week, lordship, for listing, lordship.
When it was last listed?
Last date was posting 5/12, lordship.
What is the order passed?
Leftover, lordship.
Leftover. Past the record case block, leftover feet. We did not declare leftover. What is the police station case number?
Lordship.
What is the police station?
Yes.
Police station, police.
Legal. Yes. Support, lordship.
Which case support police station case number? You are unprepared.
Sorry, lordship.
Don't make a mention. Yes.
May I please, your lordship? Lordship, I beg to mention item number 50.
50.
50, my
Yes,
lord.
ma'am.
Finally passed over the matter for the day, my lord.
CD available. 50.
Are you in interim?
No, my lord. Next week at any date, my lord.
Next it is difficult to accommodate. Okay, on Tuesday.
Obligation.
17th.
Obligation.
May I please, your lordship? Lordship, I beg to mention agreement 37. The legislature called for. Yes.
Charge sheet submitted, madam.
The charge sheet is submitted, lordship.
CS number.
My lord, CS number 74/24. Oh, sorry, my lord. 149/24 dated 29/11/24.
All right.
Obligation.
What was to be taken?
Then it was listed in supplementary list, but I could not come because there is, it was listed in the serial number 67 it was.
Okay.
So I could not come in time. I requested.
What is the order
he
passes?
said after vacation. So my prayer is on Monday, he is every there is no entry.
From which police station?
Hazard,
Hajo Police Station. What is the case
210.
number?
210/24.
Mr. Do you have that? Just note it down.
Yesterday, given.
67 supplementary list.
No, file console. We call this one. Yes.
Has recommend Q1
210.
210/24, no?
It was last year on Friday, but
No,
Friday.
no, that yesterday it was listed because it was left over on
Oh,
earlier.
yes,
day.
sir, but
It didn't appear.
I could not engage, man. Left over. So your lordship.
Wednesday.
Next.
Wednesday. I think Mr. Parasar, you have
I'll
requested.
check, madam.
18th and maybe
18.
my lord.
May I please, lordship? My lord, I have sought bail AB in FIR of Lahorigarh PS case number 632, page 8, my lord.
Last occasion, my lord, Micah was appointed on 18/11.
Actually, there are two cases filed by the same lady. And in one case, I was appearing regularly, but yet I have been shown as absconder.
আমার কাছে কি নাম দেখো না? লেখা আছে অর্ডার। কোন হলো? এক নম্বরের দুটো হবো। সেটি হলো in spite of the order of the court dated 18/11/2024, the registry did not reflect the name of the amicus curiae in the cause list. Order response number 2. Placed on twelve, showing the name of the concerned amicus curiae in the cause list.
My lord, one,
Day after tomorrow.
that we did 13 or 16? 12, I may not be
You will not be available. 16th will be on 13.
13, obliged.
I'm noting the informant respondent number 2 to the registry during the course of the day. We'll have it after the vacation. Twenty-second,
Much obliged.
legible scan copy of the session special case number 226 of 2024. Arising out of this 2PS case number 875. 2023. Along with the copy of the case diary, this will be a case number 875.
Much obliged.
Yes.
Please, your lordship, my lord. As of now, 32 days. My lord, yeah, the police, SIO police was an FIR, being allegation of
From Murajar. They're in ordinary custody from more than a month.
My lord, 17.
See, these are the matters where you are required or not. That is, you have to get the status report. That will do. Why do you need the case diary? All these are cattle thief matter.
Yes, yes, my lord.
So get the information to that extent whether is required for further custody detention.
Yes, that too, my lord.
Do it 17th.
May I please, your lordship? The accused is behind the bar since 3rd November, lordship. And FIR is at page 11, lordship. A
Yes,
GRPF,
Mr.
Actually,
There is the episode. So get it from, when are you able to get it? Now.
Mohayo.
on 3/11. 19, my lord, I will try.
Lordship, the wife of the accused is pregnant, lordship, and her estimated date of delivery is 3rd January
19.
19.
19/12.
Lordship, her estimated date of delivery is at 3 January.
19/12.
1911, 1912.
Lordship.
May I plead, lordship? 483. The petitioner is behind the bar for 35 days as on today, lordship. If I
Titabor,
6/11.
when?
19, my lord.
may I plead, this 6 is also the same year, lordship.
Pitabar, no?
Same FIR.
Common order, no? Yes, next.
May it please, your lordship. My lord, I am not named in the affair, arrested on 21/11, only because, my lord, there is a other co-accused statement that I had a transaction.
Border board.
Can it be, my lord, prior to holiday?
He'll be doing better.
Border,
Right,
my
right,
lord.
right.
Tried, my lord, because I am a tuberculosis patient, my lord.
Immediately, my lord, other than 19, we will try.
You fix it on 18, 19. Don't fix all the matters in 19.
It's 19, the border.
Okay, on 19.
Obliged, man.
My please, your lordship. This is lordship earlier rejected, but 48 days lordship, there are 60 days mandatory lordship. And moreover, she is also not well in the jail, and her 4-year baby lordship is alone without the mother. She is also suffering a lot. Like that. Already lordship, Perusa CD lordship order is there, 48 days behind the parliament. Further custodial detention might not be required lordship.
Get the information from Jalukbari.
My lord, had to.
You have it day after tomorrow,
Oh, yes,
but have the up-to-date case there, not the old one.
yes. Much obliged, your lord. 12. Go. Item number
58.
Yes,
Lordship, I am in item 58.
you have the case there, because there are. Same case there you will.
concern item is
Lordship, in item 58, FIR on page 16, 16.
39.
along with 39. No, she did not the same. 58 that series and with 39.
59, I am there, my lord.
39.
Yes, from Gorsuk when.
Next.
Already
about 40 days, my lord.
Already order
18.
was passed on 3rd of December, so
18,
17.
17.
Get it on
Deeply
17.
Can on 16, Lordship. 16 or 18, Lordship. 17 by
Not on 18. You can get it on 16th.
16, my lord, 16.
Master.
16. Oblige, my lord.
File.
16.
May I please, your lordship, my senior is on legs, he's in code number 17. He will be here in few minutes. Will the matter be passed over for the time being?
You take it up to something.
Deeply obliged.
11, 10.
11.
May I please, Your Honor? My case is item number 10. It is tagged with another item. Because we have filed this IA specifically for correction of name and case number. Initially on online, case number was reflected as 145. We have to go to Supreme Court. So we have filed this IA for the correction of the case number. But subsequently, though the case number is corrected, but our name is wrongly typed. So for such correction, we have filed this IA. So it has to be placed before Justice Mitali Thakuria. This order has been passed by Justice Mitali Thakuria. Item number 10.
Item number 10. Madam, is it connected to?
But this case 312 is already disposed of. I don't know why it has been called for in item number with 9. It is already disposed of.
Dishonorable court of this bench, of that bench, of that petition. That's why police registry has sent it.
But it is disposed of matter, and we have gone to Supreme Court. Impugn order has already been stayed, and moreover, looking to the prayer of the earlier petition, I don't find anything is there to be called for this document or tagged together with item number 9.
Madam, there are certain documents in the concern.
Real issues.
Maybe sir, not related to, but for correction, it. So my application may be placed before the appropriate court.
Item number 10. Matter relates to correction from name of the councils for the lesson number 5 and 6 in the order, in the judgment in order to the 29/10/2024 in the technical first in criminal division petition number 145/2020. 7th January. That was order to the petition 2019 passed by our leadership, Honorable Mrs. Justice in view of the registry shall please decide before the appropriate dates.
Lord, in this case, there is one important development. Supreme Court. The order passed by the coordinate bench regarding allowing the petition of the CBI. One moment. Look, you were so unorganized. For the court.
Yes.
It's the order dated 29th of
My lord,
October.
with all respect, lordship, this order has nothing to do with the
This
petition.
has,
No, no,
allow me to inform the
because
court.
here, lordship, the petition filed by them is only for getting the copies. And this order has nothing to do with the petition that has been filed today, lordship. This is another chapter, lordship, with regard to different issue, lordship. This order has nothing to do.
My brother can take the ground, what he's saying, but I'm.
Which page is the order?
In this case, Millets. Yes, Millets. Well, the impugned order is at page 48 onwards of the writ petition, Millets.
Yes.
And material paras are on page 56. From the top Millets. During hearing, it has been made clear that the prosecution has supplied the list of unrelied documents, statements, material objects, exhibits, etc., to the accused persons, including the petitioner. It is also made clear that prosecution side is required to supply remaining relied upon documents, so and so, mentioned in the charge sheet, which were not supplied to the accused till date. Therefore, prosecutor is directed to supply the said documents to the accused petitioner forthwith. This is one part, Millets. Now, second part. After furnishing the relied upon document D74 to D86, as relied on the charge sheet and in view of the fact that the accused persons were already furnished the list of a statement, the document, material objects, and so, there would be substantial compliance of aforesaid amended criminal rule of the Honorable High Court and compliance of the directions in Apex Court in so. In the state of Odisha versus D.N. Padi, the Honorable Supreme Court has held that the accused is concerned his entitlement to seek under section 91, that is not material. Now, on the next page, page 57, third para, from the top, page 57. The accused does not have right under section 207 and 208 CRPC to seek the documents which are neither collected nor relied upon by the prosecution at the stage of charge hearing. This is factually incorrect statement.
Okay.
Or if they want to insist on this, Millets, with due respect, I'm ready to accept, provided they do not rely upon anything collected by them, which they are denying that they have collected.
Okay.
Millets, what is the material fact is, after the judgment of the Honorable Apex Court in the PUCL versus Union of India, a mandamus was issued whereby the interception of the telegraph was regulated by the draft rules framed by the Honorable Supreme Court, awaiting the framing of the rule by the legislature. Since the telegraph rules has no provision for tapping of the telegraph, Millets, while there was a provision in the Act, that is Indian Telegraph Act 1885, there was a legislative vacuum. So Honorable Apex Court filled that up. And in the meantime, after some time, the legislature framed Rule 419 capital A of Indian Telegraph Rules 1955. And Millets, as per those rules, there are subsequent judgments by the Apex Court, including by this Honorable Court, that tapping has to be strictly in accordance with those rules or tapping is not to be relied upon. On that, Millets, the 4 judgments are available by 4 different high courts. Honorable Bombay High Court said that if it is not in accordance with Rule 419A, it has to be destroyed mandatorily. This is a state by the Honorable Supreme Court. Honorable Delhi High Court said the same thing, that is operating, Millets. Honorable Rajasthan High Court said the same thing, that is operating. This Honorable Court on the petition of CBI took a different view, allowed them to take the voice sample. That means they allowed them to rely upon the intercepted material. That order has been stayed by the Honorable Supreme Court, and with a direction that while trial will go on, the order will not be implemented. So, Millets, effectively, the order of the Honorable Delhi High Court and Honorable Rajasthan High Court is operating that if the interception is not in accordance with the Rule 419A, then it cannot be even retained. It has to be mandatorily destroyed. Now, Millets, what the CBI is saying, that they have neither collected the authorization from the competent authority, nor they are relying upon the authorization or permission. If that is correct position of law, which is their statement before the trial court also, and in their counter affidavit before this Honorable Court also, in that case, Millets, if they are not relying on the permission granted, they cannot rely on that in the trial. Now, the problem is arising that CBI wants to rely on the intercepted material, but at the same time, they are saying that they will not disclose whether they have been lawfully permitted or not. We are asking that, in fact, it is a relied upon document because you are relying on the permission granted by the competent authority, which is a multi-layered permission. One is Millets, the permission by the Home Secretary to commence the interception. And second is Millets, the approval of the permission of the Home Secretary by the review committee. So these two-layer permission is required. They are saying they have neither obtained it, nor they are relying upon it. All right. Then how did they tap? That is the first question. And how they are relying on it against me in the trial. So they can't have it both ways, Millets. They can't have the cake and eat it also. If they have not taken permission or they don't want to rely on the permission, that is their prerogative, their prosecution. They can choose to rely, choose not to rely. But in that case, Millets, they cannot exhibit the intercepted material against me. If they want to exhibit, they will have to show to the court, learned trial court, that they have lawfully intercepted my telegraph and they have lawful permission to intercept it. Only then they can exhibit and rely. That is what the issue raised by the previous court minutes. Honorable Justice Bor Thakur gave them an option that either you don't exhibit it or you come clean, show the authority. They agreed for that. But before the trial court, they took a altogether opposite view that no, they will not disclose. Of course, they took a stand before the trial court that they have neither collected it nor relying upon it. Once they are saying that they have not collected, not relied upon it, obviously trial court took the view that something which is neither collected nor relied upon cannot be provided to the accused. But being factually incorrect and misleading, that's why I am before my lords.
Let's take this.
Months.
Yes.
So, Millets, since the law is very clear, law says that as an exception, by way of an exception, telegraph can be intercepted. The Constitutional Bench of the Supreme Court has taken a very clear stand that telegraphic communications are part of the right of privacy, and right of privacy is the fundamental right under Article 21. Therefore, it cannot be intercepted unless there are overriding pressing situation. Now, there can be a situation when interception is necessary, my lords, no quarrel with that. Now, since the rules were not there originally, so Supreme Court has stepped in. Draft rules were provided. Later on, that rules were exactly adopted. And Rule 419A is very clear. It is saying that there will be multi-layered control mechanism. First, the intercepting agency will have to take the permission of the Home Secretary or the Home Secretary of the Union of India or the Home Secretary of the state, depending on to which government agency belongs. In this case, the Home Secretary of Union of India is necessary. And thereafter, within 1 week of the permission granted by the Home Secretary, matter is to be placed before the review committee comprising of the Cabinet Secretary, the DOPT Secretary, and the Law Secretary. And if they approve, only then interception can proceed and the intercepted material can be retained. If the review committee does not grant the permission, the intercepted material so far is to be mandatorily destroyed. Well, it becomes very clear that no investigating agency can intercept any communication by using the digital interception devices without the permission of the concerned Home Secretary and cannot retain it without the approval of the permission of the review committee, both in the case of Union government as well as state government. So it becomes a relied upon. And in their counter, they are saying that they have lawfully intercepted. If they are saying they have lawfully intercepted minutes, that means they are relying on the permission granted by the Home Secretary and the approval granted by the review committee. I am contesting that because of the serious discrepancies in their own charge sheet. They have received permission according to them as per para 31 of the charge sheet on 13th of October. I am in their custody since evening of the 12th, admitted before this honorable court also. So, Millets, if the permission was granted on 13th and I'm already arrested by them on 12th evening, how was I talking on Telegraph? Who was providing me this phone in their custody? So there are so many other discrepancies.
Let's see here, the issue is you are asking for a particular document according to you that has been relied to be relied
Yes,
by the CBI,
is being relied upon.
right? And that has not been furnished to you.
And that has not been furnished
And that
before the
prayer
honorable trial court.
That your prayer has not been considered by the London Special Court.
Yes, Millets.
Right? Okay. Now, according to you, that document is relied by the CBI. It is available from in the charge sheet. Can you show us?
My charge sheet. So Millets, I have enclosed the charge sheet. And Millets can come to page 99 of my writ petition, Millets. Page 99 minutes. Para 31 minutes.
Just a minute.
Minutes. I'm sorry.
Yes.
Millets. So Millets, para 99 of my writ petition, charge sheet, internal page 18. And Millets, para 31, third para from the top. They have given the heading, permission to intercept the phone of accused persons. So this is the compliance of the requirement of law under subsection.
No, you are in the charge sheet or in your writ petition?
I'm a charge sheet, Millets, enclosed with a writ petition, page 99 of my writ petition, Millets, running page 99.
Yes.
So Millets,
para 31.
31 minutes. So headings itself is revealing, Millets. Heading given by them, underlined. Permission to intercept the phone of the accused persons. So they are themselves saying that they have taken permission from competent authority to intercept the telephone. Now, Millets, during investigation, the DVDs containing the voice data intercepted by a special unit of CBI Kolkata had been obtained along with the original permission granted by the Union Home Secretary and Director CBI. They are relying on this, the permission granted by the Union Home Secretary and Director CBI of mobile number so-and-so, so-and-so, so-and-so. And then they have made a tabular chart, Millets. And in that they have given the telephone number, person who is supposed to be owning those numbers and who has given the permission on what date. Millets, if the chart is seen, and Millets on the left side, permission given by Shri Rajiv Gauba, Union Home Secretary, Ministry of Home Affairs. Millets, sixth entry from the top, the phone number column, Miller, first column, the fifth number from the top, Miller, this is 7983605005, Shweta Suman. Miller, this is the phone which according to them is the phone on which incriminating conversation has taken place, on which they are relying. The permission has been granted on 13th April 2015. I am in the custody since 12th evening, arrested in CBI office as per arrest memo and as well as admitted in the counter. So if I am already in their custody, Millets, how am I talking on a phone? They provided me a phone, they made me talk on the phone. So because of this serious discrepancy, the permission is required to be seen by the trial court. Apart from my valuable rights there are too many other discrepancies in this case. So Millets, with due respect, they are relying on the permission given by the Home Secretary. They are silent about the approval granted by the review committee, which is also a mandatory statutory requirement. I do not know whether they have taken the approval or not. They can inform the court, trial court, as well as my lords, whether they have, if they have not taken the approval of the review committee, then they cannot rely upon the intercepted transcription minutes. So that being the law, it is necessary that they should categorically say that they have taken permission of the Home Secretary, and thereafter the permission granted by the Home Secretary has been approved by the review committee comprising of Cabinet Secretary, Deputy Secretary and Law Secretary. And only then they can exhibit the transcription and rely upon that. They want to rely on this, hold it against me. Now, there is a technical problem, Millets. When the interception takes place, there is no mechanism available as yet where the date and time can also be inscripted in the transcription. So, Millard, it is mathematically possible that something which is recorded today can be claimed of recorded in 2010 or 2030. Only server, which might be lying out of country in a foreign country, in most of these cases, Millard, servers are in USA. Server will have only this much of record that when this conversation has actually taken place, but not the actual conversation, because that is not recorded by the servers of the service provider. So for that, Millard, all this safety and security mechanism has been provided by the Honorable Apex Court and by the legislature minutes. And for that, it is necessary to see when the permission has been granted by the competent authority and when the approval has been granted by the review committee. They are concealing something. That's why, and Millard, it is according to their own practice. It's a regular practice of CBI. I'm myself doing CBI cases in other places before other CBI courts, where they have themselves provided the permissions granted. Actual permission letters they have filed in the trial court. I can file those charge sheets with the permission of those clients or those honorable courts. So, Millard, why in my case, they want to go against their own standard operating procedure? Because, Millard, there are discrepancies. Discrepancies is, Millard, one after another. Only one is important, Millard. I am arrested in Delhi on 12th of April, according to them, 20:15 PM. And then I am brought in the night to Guwahati without being produced to the jurisdiction magistrate. Can a person who is arrested in another state be brought to another state by whose permission? Any person arrested in a particular session unit is in the constructive custody of the Honorable District Judge or his subordinate court. How CBI lifted me from Delhi and brought without intimating the local courts. And that's why, Millets, next day when they produced me before the Guwahati court, they lied before the Guwahati court that they have arrested me in Guwahati on 13th of April. Why CBI should be doing this, Millets? It's not my case that corruption should not be handled. Corruption must be curbed with all the strictness, but it cannot be done unlawfully. One illegal act cannot be curbed by another illegal act, my lord. That is not the law, with due respect. And that's why, Millets, the Honorable Apex Court has intervened and prevented them from taking the voice sample during the consideration of the SLP before their lordships of the Supreme Court. So here also in this case, CBI might be doing a good job. CBI might be fighting corruption, fine, but they should act with clean hands. They should not be violating the law of the land to comply with the law in another field, another domain. So let's, with due respect, it is a relied upon document. That conversations are also on the next pages, Milord, the page 100 onwards.
Yes.
So they are relying everything. So Milord, they are bound to disclose before the trial court who permitted them, when the permission was given, then when it was placed before the review committee, and when the review committee permitted, approved the permission. Otherwise, Millets, in terms of the statutory provisions or the judicial dicta of two honorable high courts, Bombay High Court is of course under stay, but Delhi High Court and Rajasthan High Court is operating. The material has to be destroyed, presumed destroyed, Millets. Then it cannot be led in evidence before the trial court. That is my, respectful submission, Millets.
Okay. We are in the stage of framing of charge, right?
Yes, Millets.
Trial has not yet commenced.
Not
Charge have not been.
Charge has not been framed, Millets.
Okay.
Or alternatively, Millets, my suggestion, submission to the court is, if their statement is correct, because I cannot force them to rely on something if they don't want to rely. That is their prerogative, Millets, not no. If their statement is correct, that they have not collected the authorization, I'm also ready to accept that, but the consequences must also follow. That if you have not collected authorization and you are not relying on the authorization, you may write so many things in the charge sheet. You cannot rely at that stage of charge on the content of the intercepted transcription. Whatever is, that is exactly Honorable Justice Bod Thakur posed to them, and they said we will provide to wriggle out of that situation. So I'm saying the same, I'm praying for the same, relief from this honorable court, that either they should come clean, they should produce all the permissions before the trial court, or they should exclude it from the consideration of the trial court, whatever is their decision. My lords.
Yes, Mr. Hamid. In the charge sheet, you have particularly indicated this.
Yes, yes,
And the matter is before the learned special court to consider and to frame the charge.
correct.
Now, in the stage of framing of charge, as you know, the apex court has specifically mentioned what are to be considered. It is not like the trial.
Right.
The trial, you place the documents which you rely upon.
Correct.
And similarly, if that document is not given during the trial, if you place a particular document and without giving the copy of that particular document to the accused, that you cannot place it as an evidence. That will not even accept. That's a different stage altogether that comes after the framing of charge.
Right.
Now, you kindly tell us one thing, that since you have relied upon in your charge sheet, right? Whether you are supposed to give those documents
Give
to
or
the
not.
accused or not.
Lordship, my respectful submission, I fail to understand why my learned friend is relying a paragraph of a charge sheet.
Doesn't matter.
That is a paragraph.
See, particularly,
No, Lordship,
it is your charge sheet against the petitioner
correct.
and the other accused in the case where you have relied upon, right? Those materials will be before the court, and special court to consider to frame the charge. Right? Now, thing is, since you have stated so,
Lordship.
Necessarily, the special court is required to go on repeating everything. It is not just like trial, but even on the, he has to frame his own judicious mind and accordingly he should take negligence on the front of charge. Now, while framing charge, you kindly tell us whether you are supposed to give those documents to the accuser.
While framing charge, Lordship, before framing charge, at the time of submitting the charge sheet, Lordship, we need to prepare two lists as per 173. That is list of documents and list of witnesses. Whether this with the paragraph which shows the intercepted call, whether he has supplied before this honorable court, that these are the list of documents which has been relied upon by the prosecution. If that is their Lordship, then we are compelled and bound to give those documents. Whether the petitioner has shown this document, list of documents, Lordship, today in the court, along with
the charge sheet only. It's part of the charge sheet, Millie. So on page 109 onwards.
kindly show us in the list of documents that we have relied upon this document. Kindly show us.
Well, that means they are not relying on the permission granted by the competent
No,
authority.
let us, we have.
It is not included in
Then what is the reason for making such?
The reason is because you are relying.
No.
You can't rely on something without.
No. We
Well,
have
it's a very funny
supplied a
situation.
list of documents which
travesty
have
of
been
justice.
relied upon by the prosecution, Lordship.
Well, it is a travesty
We
of
have
justice.
relied
All
upon the
right.
document, we have supplied a list of documents along with a list of witnesses on the basis of which prosecution want to launch the prosecution trial, Lordship. And we are bound to give all those documents which has been relied and reflected in the list of documents, and that we have done, Lordship. They cannot claim a document which is not there in the list and which has not been even seized.
Well, can I clarify?
No, you have already made your submission.
No, I'm clarifying this issue. I will clarify this
Making your submission on 419A of Telegraph. These things are not relevant in 207 petition. You have, Lordship, the petitioner has filed a petition under section 207 seeking.
I can clarify subject to permission of the court.
Let me, you have cleared.
Mr. Srivastava, just a minute. We'll get
Please,
back to you. We'll get back to you.
my apology.
Lordship, they are entitled to each and every document which has been relied upon by the prosecution. And 207 is very clear on that point, Lordship. And all the documents, initially some documents were not given to them. And therefore, criminal lead petition has been filed by them before this honorable court, which has been disposed of by this honorable court with the direction that all the documents should be given to them. And accordingly, Lordship, subsequently, we have handed over all the documents as per the direction of this honorable court. We have categorically mentioned in the reply, Lordship, all the documents which were not initially given to them, those documents will also has been handed over to them, Lordship, subsequently. And now, Lordship, now what is their prayer? They are going out of their prayer. What is their prayer in the petition, Lordship? May kindly have a look. Whether they are claiming all these documents. 42 page 42 or not, that is the prayer of this petition. Lordship, may kindly have a look. I will not read, Lordship. Whether the prayer contains what he has submitted before this honorable court today.
जी है उनमें खुला करेगा लेकर क्या वकालत करोगे तुम somebody
Mr. Haloi,
Lordship.
in the search sheet, certain documents are there which you have not provided.
Which one, Lordship?
Page 116.
116.
Is your, in the search sheet itself, you have mentioned that.
Those document has been subsequently provided to them, Lordship, after filing of the criminal petition earlier. All the documents has been provided which are there in the search sheet, Lordship.
Is
Let them
80 to
deny-
86, see, because what we have seen,
Lordship.
serial number 80 presently not provided, 81 presently not. This
Correct.
80 to 86 presently not provided,
Lordship.
which was subsequently have provided.
Provided.
Yes. Now tell us.
What remains, Lordship, then? In their prayer, Lordship, may kindly see what is their prayer. Page number 42, it starts from page number 42, paragraph 31, Lordship. What is your prayer in this petition? To issue writ of, may I read, Lordship?
Yes, yes.
To issue writ of certiorari or any other appropriate writ, order or directions as deemed fit and proper by this honorable court in facts and circumstances, status and was the order dated 5/3/2024, passing so and so, so and so, so and so. The Guwahati High Court criminal rules and orders that the accused be given list of document, material objects and exhibits collected, though not relied upon. We have not collected. Here in this case, the documents which have been sought for by the petitioner, we have not collected. How can we give? To issue writ of certiorari or any other appropriate writ or order direction as deemed and fit proper, directing learned trial to secure compliance of practice, direction of Honorable Apex Court, order and so and so. To direct learned trial court holding trial in CBI case number so and so of the PC agreed to provide petition the record as were agreed to by the CBI before this honorable court and recorded by the honorable court. Let us see what are the 26/9/2023. 26/9/23. Whether these documents has not been provided. All these document has been provided, Lordship, as per the direction of 26/9/23, Lordship.
Lord, 26/9/23 contain two parts. That order is before my lords. I have annexed my lords. May see if my lords. 60 to 62 minutes. Well, it's on page 61. This honorable court has recorded. Second paragraph from the top, my lords, page 61 minutes.
Then this is the
Second
grievance.
paragraph.
This is what is the
The grievance of the petitioner is so and so, and it records specifically.
Let us read the whole order.
Yes, I'm
Lordship.
reading
Let
the
us
whole
read.
order.
I'm reading the grievance of the petitioner is that he filed an application before the register as petition number so and so before the Court of Learned Special Judge Guwahati seeking for a direction to the CBI to supply material and record interception of telegraphic communication, specifically application moved by CBI under so and so, permission giving the competent authority any other communication with so and so in regard to interception telegraphic communication in the state, advisory letter sent by CBI to provide so and so, so and so, so and so. So this is the content of the petition that has been filed before the trial court. Subsequently, so and so learned appear and behavior submits that the aforesaid records are vital to defend the case of, but the learned trial court without considering aforesaid petition keep it pending for consideration due to due course by order dated so and so. So and so, Mr. Haloi, standing counsel submits no objection. This is wrong, Lordship, because your Lordship has called for that. Yes. If the document is sought for direct to be furnished to the petitioner, in view of the submission made by the learned petitioner, the learned trial court is directed to dispose of the petition. So this petition is directed to be disposed of.
Now, let's hear two things I must bring to my lord's attention.
And according, Lordship, this, as per the direction of this honorable court, that petition has been disposed of. And the documents which has been collected and relied upon by the prosecution has been given to them.
There are
The
two things.
documents which are not in
One
our
is
custody,
small
how can
thing.
we give, Lordship?
They cannot say that the judicial dicta is wrong. If it was wrong, they should have moved an application for correction. So I'm ignoring that. I'm ignoring that. Their contention is that they have not collected any permission from any authority. That's why they are not relying on that. I'm ready to accept this.
See, that is not the case. What was the direction? If a particular document is relied upon or some materials are relied
Yes,
upon,
my lord.
those are required.
Yes,
Now, what we have seen from the charge sheet,
my lord.
that the list of documents,
Yes, my lord.
in that there are certain list of 81 to 86 which are not provided. It's written there.
Initially not provided, they were
But they
withholding.
can provide it.
After intervention of this honorable court, they provided. So I'm admitting that. Now, my lord, issue is simple. They are playing, I'm using the strong word, my lords, with all humility. They are playing a fraud on the trial court. They have not
Absolutely,
included.
our objection, Lordship.
I'm saying I'm using, I stand by it.
Over CBI, Lordship.
Yeah, there is. I will
No, Lordship,
explain.
such word I will not, Lordship.
He is calling me corrupt.
Accept, Lordship.
So I'm
I'm
also
not calling
using
it
the word.
corrupt.
You should not mind. It's
an
a legal
allegation.
word.
Are you?
Fraud is defined in the law, and it is judicial dicta I'm using. I'm not using unparliamentary word. Will it be due respect? Nothing personal against any officer of the CBI. It is institutional issue. They are not including the document in the list. All right, their prerogative. But in the body of the charge sheet, they are relying on the outcome of the permission granted. Mala, how do I defend at the charge itself, assuming, milords, evidence is collected illegally and is not admissible as evidence? They will say we are not relying on the permission taken, but we are relying on the evidence. Now that becomes a very important question of law, that whether the CBI is permitted under CRPC and PC Act to rely on something, the permission for which is not being relied upon, and permission is mandatory prerequisite for collecting that evidence. So this becomes a question. My lords are a writ court. It's a constitutional court. And writ court can go into any issue material or germane to the main dispute. So, my lord, what they are doing, they have prepared a list. All right. So in that case, my lords, my prayer is that anything which is not mentioned in the list, including its consequential outcome, can also not be relied upon the trial court while it's considering the charge. If that is acceptable to them, I bow down to this honorable court. Alternatively, they can amend their charge sheet with the permission of the trial court. How can they rely on something? The enabling authority is not being relied upon. I'm not relying on the Constitution of the India, and at the same time, I'm seeking relief from this honorable court. What kind of argument is this on CBI? I'm unable to understand. So they must rely on the enabling authority, or they cannot rely on the consequences also. That is the whole issue, my lord. That's why I'm before my lord for the second time.
Lordship has called for certain earlier petition regarding this. May I have a look at it?
Nikalu writ petition number 4.
Yeah.
Writ petition number 4.
One more petition is, I think, disposed of. Lordship. Wait up to. This is the
No, there is one more pending, my lord. Petition number 6 of 2024. That is on the issue of the public prosecutors of CBI, not on the voice or interception
I
issue.
think, Lordship, criminal revision petition or criminal petition, Lordship.
That is 312.
Revision or not criminal revision petition.
312.
Criminal petition.
Item number 10, it is there.
Lordship, kindly have a look into this. where Lordship, even though we have not relied upon, all the copies have been supplied to them.
What has been supplied
That
to
green
us?
color flag. While disposing of this petition, criminal petition, Lordship, the permission and all from the competent authority, Lordship, they have given to.
नहीं मिला है।
Huh? It is there in the record. We have
No,
supplied copy.
नहीं मिला है। कहाँ है भाई? दिखाओ। इनका रिप्लाई दिखाओ ना 312 में इनका कुछ होगा लॉग तक।
Yes, sir.
Yes, sir.
Yes, sir. You have not seen. I made my submission on that point on the last occasion also, that all the.
ये कब फाइल हुआ था? ये मेरे पास नहीं है। नेवर शोन दिस टू मी। एनीवे चलो। You're an idiot.
Mr. Srivastava, take it.
Lordship.
Mr. Halu, take it.
Lordship.
Mr. Halu, in that petition,
Lordship.
your objection, where you have mentioned that all the documents that you have given.
Lordship, we have replied to their petition, Lordship. This, Lordship, I also forgot, Lordship, and on last occasion, I had made a categorical statement before this honorable court. Therefore, this record has been called for, Lordship.
No, that was that particular criminal division petition was prepared by the CBI.
CBI. For taking voice sample, Lordship.
Which was rejected on the basis of the case there.
No, it was allowed.
It was rejected by the trial court, but subsequently this honorable court allowed, and now Supreme Court has stayed the order of this honorable court. So, effectively, they cannot take the voice sample for the time being. Well, the second limb is still remains uncomplied with because this is the permission given. I stand corrected. I'm sorry, it is my apology, Milord. My office should have informed me this.
You have argued on this document on the last criminal petition.
My apologies.
Forgot that.
Yes. So, Milords, they are still not showing it to the honorable trial court minutes. It is to be seen by the trial court minutes. This honorable court, of course, has considered the legal issue, whether they can take the voice sample or not. But trial court will go into the evidentiary part, Milord, which this court has not seen. Milord, the second part, that approval by the review committee is still being withheld by them, or they have not taken, whatever is the facts. They may inform the honorable court themselves. And second, Milords, page 86 of this petition, if my lords can just see, if I can request my lords.
Just a minute.
My lords, my apologies.
Mr. Aloy,
Lordship. Sorry.
Yes, Mr. Srivastava,
Lordship.
all these materials have been already provided in the,
Minutes now, with due apology minutes, I must not.
that's why I took time to go through all these records.
No
and
minutes, I will
verify.
draw my lord's attention to, in fact, probably both of us are slightly in the wrong. And I'm sorry, judicial time is.
Okay, now we have
My
heard
lord,
the-
item, no, my lord, this is material. D, because Mr. Haloi has said that they are not relying. And that is not included in the list. It is included minutes. D 158, D 159 onwards to D 168, 169, 170.
You're reading where?
Page 122 of my writ petition minute. That is the part of the list of the documents relied upon. It's a relied upon document minute. It is mentioned in the list. That's why.
We have supplied.
This has not been supplied, but it has been submitted before the court.
Yes, yes. please.
Well, this page 122, serial number 159, that is D 159, that is the document, and up to minutes 171. These are the permissions granted by the Home Secretary or the Director CBI for interception of the telegraph. They are relying on this. Well, this is the first stage of the permission. Permission is a composite process of two stages. First, permission by the Home Secretary, and in extraordinary situations by the Director CBI. And then minutes approval by the review committee, which is a high-powered committee comprising of the three senior-most bureaucrats. So they are not relying on the approval granted by the review committee. In that case, minutes, the law is very clear. It is a statutory provision as well as the mandamus of the Honorable Apex Court, that if the approval of the review committee is not granted within 7 days, then the intercepted material is to be mandatorily destroyed. That is what Bombay High Court has said. That is what Delhi High Court is saying. That is what Rajasthan High Court has said. So, minutes, if they are stating that they have not taken the approval of the Honorable Cabinet Secretary, a review committee headed by the Cabinet Secretary, in that case, minutes, they cannot rely on the consequences, because enabling authority is a must. It's a question of jurisdiction, minutes. If jurisdiction is not available, no authority, this Honorable Court is also no exception, can undertake any exercise and pass any order or do any act. So,
No, these documents have been already provided to you.
my lord, these have not been provided, 159 onward, but now we have got it.
No, Lordship,
These were submitted before this Honorable Court, not provided to us in the trial. That's why we have been fighting for so
If that is
much.
so,
But now
Lordship,
it is on the record of the court, we can take certified copy also. My purpose is served.
if
Whether-
that is so, they ought to have mentioned in their petition, have they mentioned that this document?
That may be an omission on my part,
Mr.
but
Srivastava has submitted before the court. Mr. Haloi, sometimes it might be something in the.
minutes, I apologize. I should not have
That
consumed
actually
the
you have
judicial time,
accepted.
but I apologize. Mistake on my part, my
No,
office,
you have
part of my office, but
You have pointed out that these documents are not already processed. And he has
now,
also accepted.
these documents are before this Honorable Court, so they are disclosed. I mean, disclosure is the mandatory, so that is disclosed. Second part, Milord, the approval granted by the high-powered review committee, which is also law, that they are not disclosing, still not disclosing.
Not required.
It is required.
See,
Minutes.
if those documents are taken into consideration at the time of evidence, necessarily they are bound to do it. You can
Yes.
always raise that question at the time of trial, that these are provided on the basis of this charge has been framed. But during that trial, if they fails to provide any such order of the review authority, suppose they
That's
cannot
something.
keep their
Yes,
seal.
I
That
go down.
DVD they are talking about, that the voice sample or the voice recording, what has been recorded, will not be executable unless there is an order of the reviewing authority.
Yes.
It has to be destroyed. They may keep it because of these orders been given to them.
Yes.
But that, unless there is an order of the reviewing authority,
My lords.
that has to be automatically destroyed under the.
That stands destroyed, in fact.
Definitely.
Stands,
So
I mean.
it cannot be placed as a piece of
Milord,
evidence.
that's the whole problem is, with due respect, I'm sorry, I'm interrupting, Milord. They are saying they have not taken the permission of the review committee. Agreed. That again is their prerogative, they take or not take. But they are relying on the material intercepted over a period of time, meaning thereby they have retained those intercepted materials.
See, while framing the charge,
My lords.
always that can be placed before the court. And it will be on the objection because at the time of, if it is relied upon, they have to place the reviewing authority's order.
All right, my lord. So,
That's all.
my lords, and then probably this issue can be resolved by my lords. But one thing before that, my lords can see D165. Why I'm insisting, why I'm consuming precious judicial time. D165 of this or their petition, my lord, that petition number 312, which they have enclosed.
165, yes.
Yes, my lord, kindly see the last para only. This pertains to me. The order shall remain in force for a period of not exceeding 60 days from the date of commencement, that is 9th April 2018. Order is issued on 13th April 2018. There is no provision in law when they will intercept the phone for 5 days illegally and then go and get it regularized by the Home Secretary.
Please come in the same lot,
My lords.
what we have noticed. That is why we took time to look into it. In the same lot, there is also an order.
My lords.
That is D170.
That is by the director.
That's by the director.
Yes,
But
Willets.
because it is specifically mentioned
Yes, my lords.
to approve the interception process for operational reasons in emergent cases where obtaining prior permission of the competent authority is not feasible.
But
And
I
that
will.
is why most probably you see at D165,
Yes,
it was considered from 9th of April.
my lords, I will contest this order on merits at appropriate stage. That's separate. My lords will permit me my liberty.
That is always.
Yeah,
you can-
separate. My lords, with due respect, that's the legal language. My lord, what I am saying is, the Home Secretary of Union of India is not a writ court. He is an executive authority. He exercises powers of the president conferred through the minister under Article 53.
After all,
He
the-
cannot regularize something which is going on illegally.
That's what they have, what we found at D1.
But that is a matter of evidence, my lord. That I will take up at the final argument or maybe in the course of cross-examination, etc.
And I'm sure that those things are there before all the
So-
details are before for giving of charge. Now,
So,
all
my lords,
the documents.
at the stage of charge, the law is clear. My lords knows much better than me. My lords are dealing
Why not?
hundreds of
Always
cases
are.
per day, every day. But at the stage of charge, assuming what they are saying in the charge sheet,
It is well
that to be
settled by the
correct.
apex court. What
That
is
to be
to
correct.
seen
That's
in
the apex
charge,
court is saying in
right?
n number of cases.
Charge, you don't
High
have
courts
to
are
go to
saying.
what is the materials and the evidence.
Yes,
that
yes,
is not the report. It is
So
prima
they are
facie
saying,
satisfaction is required.
that's what I'm saying. Let this be recorded by this honorable court that they have not taken the permission of the review committee.
That will not make it because this is not the request.
Because
for the framing of
that will make a bearing, Millets. Because that I will request, Millets, with due respect.
That's what we are saying. Before the trial court or at the time of framing of charge, you can always raise that issue. And it is-
Because at the time of trial charge, I cannot go out of this list, Millets. Here I can go. I'm in writ jurisdiction, Millets.
Here in the list of documents.
Yes, Millets.
There is no such order by which they have said that has been the reviewing authority's permission is there. There is no such document.
There is no such document.
Then it is
They are not
fine.
disclosing.
If it is not there. If it
Yes.
is
So
not
my lords
there in
can,
the
my lords
charge
can,
sheet,
what is falling from my lord's
if it is
mouth,
in the charge sheet,
that
why should
itself
be
my
in the
lords may
order?
record.
Why should be in the order?
If it is not recorded, my lord, trial court will be in a difficult position, my lords.
The prosecution authority can go beyond the search sheet. Definitely not.
Not cannot.
Otherwise, they can also have to take permission and to file another search sheet or additional search sheet, whatever. Right?
My lord,
That is the
permission now
of the
cannot be
court.
taken. It cannot be regularized because that is stand destroyed.
Permission of the court.
Permission
Court
of the
can-
authority, prescribed authority, my lord. Now,
Okay, well,
court
but
does
thing
not
is
have
this-
jurisdiction to grant the permission for interception.
Definitely.
So-
That
so
we are not
minutes,
talking about that. If they-
starting-
Here in the list of documents, apparently there is no such order of the reviewing authority.
Yes, my lords.
Fine.
So,
If it is not there, where from the prosecution you will place it?
my lord, there is another issue, my lord. There is a judgment, there are judgments by the constitution bench, including one Puranmal. Now, Puranmal is of course in the context of income tax, so it becomes debatable. So I can't raise at the charge. It court of course can consider. Puranmal says that even if the evidence is illegally collected, the facts were there, that a search were declared illegal subsequently by the court. The income tax department went ahead and used the material collected by them in the search. So a aggrieved taxpayer came to the Supreme Court. Supreme Court said legality or illegality of collecting the evidence is one part. And you can prosecute the authority for illegally collecting, and admissibility of evidence is another. So here the difficulty will arise not for the trial court, because trial court are again not permitted to use the judicial discretion. They have to go by the whatever is
That is
written.
not a reliable thing at the relevant point of
So, Millets,
framing of charge.
in this case, if my lords
No.
can just record for my satisfaction,
See,
Millets.
what we have seen, yes,
My
in
lords.
the charge sheet, that particular.
So my lords, can you just note down my submissions that so that trial court has the benefit of knowing the judicial mind of this honorable court, that
See, it is apparent this apex court has laid down the law very well, cannot go beyond the search. That's all.
but my lord, something should be flow from the order that my lords have considered this issue.
Their lordships have.
I will not argue beyond, my lord, but my lord, with due respect.
Okay, we'll look into it.
Yeah, my lord, some observation that this has been raised before my lords and my lords have come to some conclusion.
We'll look into it.
So, because my lord, as per law, with effect from 20th April 2013, the entire intercepted material stands destroyed mandatorily by force of law. So something which stands destroyed on 20th April 2018 cannot be exhibited.
No, because time limit is there.
Lordship, I have one more.
Time limit 7 days, my lord. 7 days in 419A, 7 days.
Time limit is there.
Yes.
And that's why, that is the reason why we are saying that if within the time limit, you have seen that the order of the secretary is also from that particular date.
So even if my lord's secretary is regularizing the permission given by the director, whether that can be done, I'm leaving it for separate some other time. But my lord, permission starts from 9th.
For that duration only. That duration only.
That for 7 days, interception could have gone even without the permission of the review committee. But if review committee approval is not granted, then closed and material destroyed.
That is the law.
That is the law, my lord.
So
my lords, I am taking the outer limit 20th April 2018. Since approval was not granted by the review committee, everything is to destroyed on that date by operation of law. That is material, my lords.
Lordship, in reply, Lordship, what I want to submit is, we have received neither any, I mean to say, from review committee, there is no letter from their end stating that it was not destroyed, it was not regular, it was not irregular. So at that point, we have no comment to offer, Lordship, because we have received nothing, Lordship. From that end, from review committee, the matter has to be placed before we have sent it. And from the review committee, we have neither got any rejection order that these interception calls are illegal. Therefore, it should be rejected. We have not received any such communication. Let me submit.
Procedure not like this.
So
Procedure not like this.
therefore, Lordship, it cannot be presumed.
Indian Telegraph.
Yes. There's a certain time limit has been prescribed in 419A, Lordship.
7 days. Is the writ coin? Writ number 4. Writ number 4.
No, that 14.9A will not be available in Telegraph Act, Lordship. 14.9A will not be available in Telegraph Act, Lordship.
Where is in?
14.9A will have to go from net, Lordship. 14.9A to Lordship. It has been subsequently incorporated. 419A, sorry. 419A, not 14.
My lord, this is 419 capital A.
Yes, that's right.
Yeah. So my lords can.
419A. 419A. ये बाहर गया ना ये तो नेटवर्क Indian Telegraph.
It is included by writ petition number 4 of 2000, the earlier writ. I have enclosed it.
That 2007 rules you are talking about.
Yes, 2000.
It has been amended in 2017 again.
Yes, my lord, 2007 rules. My lords can come to para 16 of the rules. Para 16, let's.
Yes.
This is the review constitution of the review committee.
Yes.
And para 17 minutes is the material.
Yes.
The review committee shall meet at least once in 2 months and record its findings whether the directions issued under Rule 1, that is the Home Secretary, in accordance with the provisions of so and so of the said act, that is whether lawful or not. When the review committee is of the opinion that the directions are not in accordance with the provisions referred to above, it may set aside the directions and orders for destruction of the copies of the intercepted message or class of messages.
Correct.
So it is for them,
if it is not in accordance, if it is accordance, Lordship.
What you are saying is that, yes, following this provision, whatever the interception you have made, and you have forwarded to the review committee.
Yes.
You are yet to receive
The
their
communication.
communication,
Yes,
accepted, rejected,
Yes.
whatever,
yes, correct,
right?
right.
That you are saying on the basis of your authority.
Yes,
Provided they have sent it to me, that I'm contesting, they have not
It is
sent.
not- It is not. that is
It
why
is
you're
for them
asking.
to satisfy the court
That
that
you
they
have
have
forwarded to
sought
the
the
review
permission of the
committee.
review committee,
It is-
approval of the review committee. I'm saying they have not even approached the review committee, so that is material. That of course is matter of trial, Millets. I will take up a trial. Trial, Millets. But Millets, 16 and 17 have not been complied with. Therefore, they don't have any authority to even retain. It is for them to go and pester the review committee. They are the beneficiary. He who wants to enjoy the exception in the law has to obtain. I have come before my lords. I can't say that my petition is pending in the High Court. Therefore, I will go on availing. It's for me to bring to the notice of the Honorable Court that there is a time limit. There is a limitation involved, and therefore it must be considered.
Okay.
My lords.
But Mr. S.K. Srivastava, Learned Counsel assisted by Mr. N.J. Lota for the petitioner. And Mr. M. Halloy, Learned Special Public Prosecutor CBI for the respondents. Order is adopted. Itu category বলো।
Next topic is license. Is it legality method? Oh, I did that.
My file order. It is planning. I should put it. Okay. The second file. And for the protection from the রবিবারে টিকিট দিব। Okay.
highly.
Please, Your Lordship. My lord, this writ petition is filed by the petitioner's lordship before this honorable court lordship for quashing of an lordship complaint case by the CS number 94/2024 pending before the court of 9th Metropolitan Magistrate Kolkata lordship due to want of jurisdiction lordship. Lordship, what happened lordship? Petitioner number 1 is the lordship partnership farm lordship. And 2 and 3 are the partners lordship, which was constituted by the partnership deed lordship. Thereafter, they have started one lordship, business lordship of showroom lordship and selling and service of the TBS lordship two-wheeler lordship. And lordship, accordingly lordship, the respondent number 3, which is a finance company, NBFC company lordship, they have advanced some loan lordship towards lordship acquiring the two-wheeler stock lordship. And lordship, after COVID lordship, that lordship dealership was lordship terminated, and lordship, the TBS company already taken back all the stocks lordship. But there are some disputes regarding unpaid due lordship between the petitioner. But lordship, the check lordship, which was their alleged lordship to be issued by the petitioner lordship, that was your lordship may kindly come to page 29 lordship, the complaint lordship. In the complaint petition lordship, the respondent number 3 lordship stated that the check was issued on 1st of December 2023 lordship against the cash credit account of the petitioner lordship. Although lordship, that very account was already become NPA lordship with effect from lordships 26/1/2023 lordship. So this is very much impossible lordship, which was already inoperative in the month of January of 2023 lordship. How a check would be issued on 1st of December after almost 12 months lordship. So, and moreover lordship, there is a provision for arbitration lordship. So without choosing them by them lordship for arbitration lordship, they lordship filed the complaint case lordship just to harass the petitioners lordship, bringing them to the Kolkata lordship. Although they have a branch office at Silchar lordship, which is already operating lordship. So if any dispute lordship, they may also go for arbitration or lordship, they may file a suit in the Silchar court also lordship. But the Kolkata court had no jurisdiction lordship to try the suit.
Where is your agreement?
Lordship agreement, I have not, lordship, annexed lordship, because that was not available with me. That was already taken by them lordship.
That has
At
to
the
be
time of
copy with you, unless we will know where it is in the agreement, if you have signed,
lordship,
that
because
jurisdiction will be with this.
that lordship agreement, I cannot access lordship.
That you must have a, definitely will have a copy. Don't say like that.
Because lordship,
You
that
have
was,
taken loan and you will not have a copy. Is it
no,
possible?
that was not a loan actually lordship. That was a business advance loan for acquiring lordship, some assets lordship. And that was already taken back lordship. So some disputes lordship, but the facts remains.
Unless you place it, prima facie, you have to be satisfied.
Lordship,
That you have taken. That
yes, lordship, but that agreement lordship, the respondent number 3 is very much having it
You
lordship,
might having it, we don't know.
because I
On
am
that
not having
basis,
it
Why
lordship.
should, unless you establish your case, why should you issue notice? You have to show it. As because you'll file it and you'll issue a notice, it's not like that.
Lordship,
Unless you can establish your case.
because lordship, prima facie lordship,
Prima facie is
the
whatever
Ellis
is
check
the
lordship.
agreement, we do not know. That you have to place it first.
But lordship, that agreement lordship, I am not having, because that was already taken by them lordship, and at the time of
Cannot be.
sanctioning the loan lordship, I don't know that what will happen lordship, and they have already taken it, and I,
Then, sorry.
lordship, if your lordship issued notice lordship, they may
First of all,
produce it
show
lordship,
us-
even
we
I.
don't know what are the grounds? Where from you are saying that the arbitration clause? Where you have said, from where you can show that there is an arbitration clause? Show us that clause.
Lordship, I am.
Show us that clause, where is that arbitration clause was specifically incorporated? There has to be some agreement. Where is that agreement?
That agreement is there,
Where
lordship.
is that?
But that agreement.
From where will you show that there is an arbitration clause in the agreement, and where is that particular agreement?
Yes, lordship. This is, I have specifically categorically stated in my petition,
That will
lordship.
not do.
That agreement, I cannot access it, lordship, now,
In
lordship.
that case, it will be difficult for the court to issue any such notice. We do not know. Why should you issue notice? Is your case you establish? That's all.
Because, lordship, the jurisdiction is also a matter of. That's
Definitely will
lordship.
consider, it will be in that agreement.
Because, lordship,
If it
they
is in
could
the
not
agreement, it is
provide.
specifically mentioned that it will not be in Kolkata or in Delhi or wherever these offices are there.
Yes, lordship, but the lordship, that facts, lordship, because now, lordship, I could not able to get the agreement copy, lordship. Because at the time of sanctioning, lordship, they had taken everything, lordship, and
Council will
moreover
not
that.
accept it. Will not accept.
Moreover, the Ellis check, lordship, that was as a security, lordship, that was issued.
So whatever that NIX should have been, that particular should have been initiated in the concern, fine. There has to be certain reasons that the agreement you have to.
Because, lordship, only the respondent number 3 is able to provide it, lordship, before the court, lordship, and until and unless they are not summoned by this court, lordship, I could not able to get it, lordship.
Come to page 31, para 19, para 9.
Yes, Lordship, that was just for bringing the jurisdiction, Lordship.
That's true. That is the reason. So,
But when they have communicated from its branch office situated at Silchar, Lordship, and everything was done at Silchar, Lordship.
so that is the reason we are asking you.
Until Lordship, that respondent number 3 would not be summoned, Lordship.
Or also, if you also bring notice, you have to satisfy the court first, right? Unless you can satisfy, we will not pass any order.
But Lordship, nothing more than these records, Lordship, I am having.
We can grant you time, otherwise we will not. The provisions of the NI Act are very clear. Apex could have clarified again.
Yes, Lordship, I am also agreeing, Lordship. But the facts only remain that Lordship, just for harassing, Lordship, of a
Earlier
business.
the things were different. Now the things are different, right? And now the Apex could have clarified that issue. The NI Act. Up to you. We can come after some time if you have any materials. The probably counsel for the petition and materials are done for you.
All right.
Map is Lordship. Here is bail application, Lordship. The petitioner is apprehending arrest in connection with Tamulpur PS case lodged, registered under section 8 of POCSO Act.
Take steps
My lord.
on the informant respondent number 2, opposite party number 2. During the course of the day, to the registry of this court. And we should take steps on the public prosecutor. Yes, this has to come from Tamulpur.
Tamulpur.
Take steps during the course of it.
Highly available.
Tamulpur,
Yes, my lord, only 1 week left, my lord.
after vacation,
Yes, second week of, my lord, January, my lord.
give us a date.
On 6th, my lord.
Highly available.
6th of January.
Take your steps first. Yes.
Wait, please, your lordship. It is pre-arrest bail, lordship. FIR is page number, lordship 14, relevant portion, lordship.
She delayed.
NDPS.
Sir, sheet has been laid down, my lord.
Rashid has been filed.
Yes, my on let's say page 38. The stage of appearance is
Page number 41, ma'am.
Yes, lordship.
Serial number 16. Then second part of serial number 16.
that's
Your prayer in this prayer is bail application cannot be considered. There are appropriate forum, you know that, will not indicate that, up to you. Suppose the appropriate forum. Otherwise, we have to dismiss this. Tell us, up to you. Hmm? There are appropriate forum where you can approach. Not as a pre-arrest bail application. There is an appropriate forum, not in pre-arrest bail application. Tell us, we have to dismiss it otherwise.
Up to you. Lordship.
border.
Up to you, lordship.
The border Germany. And subject to correction, my lord, whether my lord merit is otherwise, my lord, but there is my lord in from our High Court division bench judgment, my lord. Yes, ma'am, that AB now, my lord, AB they can file for the AB, my lord. A reference was made, my lord, regarding that, my lord. They are different from different high courts. They are different opinion, my lord. Our division bench has made it clear.
Do you have the BNSS with you?
Otherwise, also, my lord, as a absconder, my lord, he is not liable for AB, my lord.
say 582, new provision. Five eight two. Mr. Goswami.
Yes.
2452.
Yes, sir. It's IPC.
It is not there? Give it to us, give it to us. It's wrongly, newly numbered.
Yes, sir.
Earlier provision 482.
Yes. Now 438, madam.
Sorry, I'm wrongly said 528.
Yes.
528.
Very good.
Third, R. Mazumdar Council appearing for the petition. J. Ghosh. J. Ghosh. Okay. And Mr. Mary Goswami, additional public prosecutor.
Very good.
Petitioner is a substitute accused in yes, case number 195/2023 under section 21 bracket B small b of the 29 of the NDPS Act 1995, in which he was shown to be an absconding person. The learned trial court, IG Court of Learned Additional Session Judge FTC Kachar Silsat after taking cognizance of the offense in the sections 21B of the 229 NDPS Act, issued summons to the accused person, including the petitioner. In spite of service of summon the petitioner, he did not appear before the learned trial court. As such, the Court of Learned Session Judge FTC Kachar Silsar, I ordered it is 03082024. This was non-bailable warrant of arrest against the petitioner for his appearance in the said NDPS case number something such. GR number 4693 of the 202. Logotical. Yeah, after taking cognizance of the offense. Yeah. Let's say. NDPS case number 195/2023, corresponding to GR number 46, has been registered as NDPS case number 8. NDPS case number 83/2022. Proceeding with the depending before the court of London additional session judge FPC Pachar Session. Not Pachar like summons. NBW. Hence this bill application. Pre-arrest bill application by the petition. Namely such and such by such and such. Apprehending is arrest inside NDPS case number 8. Considering that the petitioner that the petitioner is asserted accused under section such and such, and summons have been duly issued upon him inside NDPS case number such and such, in which he failed to appear, it is not a fit case to grant pre-arrest bail with the petitioner in passage, and accordingly stands dismissed. Yes, next.
Obliged, Lordship.
Made this lordship.
Take steps on the liquid of non more. Take steps on the informant respondent opposite party number 2 during the course of the day. Yes,
Lordship,
the record has to be called for.
Lordship from South Salma Suksar, minor.
On what is can
On 9th of January.
We have fixed many cases on 9th.
Lordship.
We'll have it after.
After Bihu, man.
Let us see.
Lordship.
Okay, okay, on 9th of January. Is in it's anticipatory, right?
Anticipatory, man.
After vacation.
Yes.
That will be, let us have it on 20. Scan legible copy for it, along with the copy of the case diary of Suksar Police Station case number 59/20. From the Court of Learned Special Judge Pokso, South Salmara, Mankacha. Next steps.
My lord, kindly see the affair, my lord.
You are not on FIR. What steps then we consider? Yes, from Mankacha, Mr. Goswami. Immediately after vacation.
Yes, it is boy
7th or 8th. Whatever. Take steps on the informant respond number 2. Lowry got
16.
9. Take steps first on the course of the day.
May it please your lordship.
You have the case diary?
Lordship.
Tell us so this custodial detention is required or not.
Lordship, accused petitioner has gone and recorded.
No, that's you are already the interim. We know.
Lordship, he has appeared, my lord. Probably may not be.
When did you appear?
The petitioner appeared on lordship. The date he appeared on almost 10 days back, lordship. 12 days back. I'm not getting the exact date, but I know he has already.
21/11. 21/11.
21/11. Almost 11 days.
But Mr. W. made counsel appearing to the petitioner and Mr. N. P. Goswami at date number. Apprehending his arrest. The petitioner, namely such and such, has filed this application, created bail application at section 482 BNSS. Praying for his such and such. In Kamalpur Police Station, case number 164/2024. As for the affair of the case, dated 30/10/2024, lost before an officer inside the Kamalpur Police Station by the complainant, is that the petitioner, along with another, accompanied the complainant to the affair named accused person Aniruddha Kakoti, where an agreement was executed by said Aniruddha Kakoti to sell a plot of land measuring 25 acres to the complainant for an amount of rupees 85,00,000. As the accused person Aniruddha Kakoti failed to hand over the land to the complainant, return an amount of rupees 5 lakhs refunded returned to him. Initially refunded and then rupees 3 lakhs in April 2024. But the remaining amount of rupees 77 lakhs are yet to be paid. According to the complainant, neither the land has been handed over by the state which person pick up the Friday. Now he has pursuant to earlier report by order is 19/11/2024 granted interim bail to the petition. Then said formal prepares case number. Mr. Goswami and Anderson public prosecutor from the case there is submitted. The petitioner pursuant to the said interim bail 19/11/2024 appeared before the concerned investigating officer of the case on 21/11/2024. From the case there, Mr. Goswami also submitted that the petitioner is cooperating for the investigation of the case. Considering the process. Interim bail granted to petitioner on budget. Very specific terms of money. Give a minute to that.
Obliged, your lordship.
May I please your lordship? FIR is page 16.
CD received, my lord. Here the 5.9 kg of my lord ganja is from the house of the petitioner, my lord. When my lord petitioner, when the police team came, my lord, he somehow managed to escape, my lord. And also there are instances that he is a habitual drug peddler, man. He was arrested earlier also, and case number reference has also been given, madam.
I am on two
So
grounds.
he is not eligible for AB at this stage.
May I submit, Your Lordship?
Sure, why not? Please.
Yes, Your Lordship, with respect to section 42, I'll just read the FIR at page 16. With due respect and humble submission, I would like to report that on 2022, an input was received by OC Yangia PS that one Mustafa Ali, so and so, has been dealing again in the illegal business of ganja after
First
coming
of all,
out from
tell us, what's your name?
DK Agarwal.
Have you signed your color?
No, Your Lordship. I've been led.
If you are not a senior advocate.
Your Lordship,
Don't make.
I'll continue. Your Lordship, we are contending on two contentions. One is the compliability of section 42, Your Lordship. Your Lordship, if you see the second paragraph of this particular FIR, it says that as directed, a team of police personnel has been constituted comprising self. Self is a SIP, then it's
You are Mr.
a TL Oscar, Your Lordship. SIP, one LNK and one section of Assam Police Battalion, Your Lordship. Your Lordship, and thereafter they are quoting one notification which was given by the Assam government with regards to the search and seizure which can be conducted by any officer above the rank of an inspector, Your Lordship. Here, Your Lordship, the team constituted consists of a sub-inspector, Your Lordship, which has been clearly reflected in the FIR by the Lordship.
That is the Assam government notification. That is there. No, there is notification. It was extended up to.
Regarding the submissions, regarding applicable section 41, 42 or not, that is not at this stage, that is not a relevant ground for bail,
No, there is a notification.
Yes,
Because extended, I think so.
Yes.
There was a notification. This time.
Your Lordship, they have relied on the notification.
Whether it complied or not, that has to be a different chapter, those materials that has been found, that cannot be negated now, at this stage. They might have a good ground in the appeal, that is the different thing,
We approach the appropriate forum.
Your Lordship.
There is a proper forum for that. You know what to do.
Your Lordship.
Mr. T.L. Oscar, counsel appearing for the petition. And Mr. M.P. Goswami, additional public prosecutor. Apprehending his arrest, the petitioner, namely such and such, son of such and such, has filed his pre-arrest bail application. Filed this bail application under section 48. BNSS. Praying for his pre-arrest bail in Rongia police station case number such and such. Under section 30. From the case diary. Mr. Goswami and additional public prosecutor. That the petitioner is a habitual offender. And was also arrested in connection with Rongia PS case number
64/24.
64/2024 under section.
Under same sections.
Within bracket small 1. in bracket 21 in small b of the Minvi Act was arrested on 14/02 to the in case number. From the position from the house of the petitioner in presence of independent witnesses during such where is the recovery?
May kindly come to the FIR.
Two numbers of white color polythene bags containing leafy substances suspected to be ganja. Weighing about 5.981 kgs together with the plastic polythene bag. However, on arrival of the police team, the petitioner managed to clear away from his house, and as such was not found in his house. At this stage, Mr. T.L. Askar, counsel appearing for the petition, submitted that the affair of the case was lodged by one sub-inspector of police. Further, the state sub-inspector of police made the search in his house and also seized the suspected NDPS substance from him. According to Mr. Askar, sub-inspector of police is not authorized to search and seize under the NDPS Act. To that extent, what is that notification?
Your notification is the notification. Yeah, Lordship.
Notification of the government of Assam under 25/04/1995 as well as notification dated 15/05/1994 clarifying that it is only the rank of police personnel in the rank of inspector can enter, search and seize and arrest under the NDPS Act. However, from the perusal of the FIR, it can be seen that the concerned complainant, the complainant, the concerned sub-inspector in police, the complainant, comma, concerned sub-inspector of police, indicated the government notification of the government of Assam number EX 145/85/290 dated 25/04. And such. Under the provision of section 42(1) of the NDPS Act to enter, search, seize and arrest without authorization. From the reading of the notification dated 25/04/1995 placed by Mr. Loskar, also can be seen that the government of Assam by the said notification dated 25/04/1995 have empowered all excise officers of the above rank of Assistant Inspector of Excise, comma, police officer and above the rank of Sub-Inspector of Police and Drugs Control Officer and above the rank of Inspector of Drugs to exercise the power and perform the duties specified in section 42 within the areas of their respective jurisdiction, and also authorized the said officer to exercise the powers conferred upon them under section 67 of the Act, NDPS Act, with effect from the date of publication of the said notification by official gazette. As the concerned complainant, as the sub-inspector Anand Ralston, UB legal police, as per the notification dated 25/04/1995, he is authorized to enter, search, seize and arrest under the NDPS Act. As the case theory indicates sufficient intimating materials against the petitioner. This previous biology, such and such. Indrogia PS case number such and such. Stands rejected.
Much obliged.
Yes, next.
May I plead your lordship? Kindly pass over the matter for time being. My senior advocate, flagged before the court number 19.
Now, in this case, one report from the IOS call for whether any application for DNA test was not. But I have talked with the IO, my lord. It was applied after the birth of the child, and DNA test was also done. My lord, yesterday, yes, he has received it, and it will be submitted before the court in a subsequent session. My lord, it will by tomorrow or day after tomorrow, it will be submitted in the court. Otherwise, my lord,
we'll have it next week. We'll know the report of the DNA test.
Yes, that may be yes, call for. It will be submitted, my lord.
We have admitted that the child is of the petitioner.
Yes.
And the statement of the victim girl is very much clear that the involvement is mutual, my lord, and
How old was she?
16 years. 16 years.
Or consent will do? How old are you?
my lord,
How old are you?
I am, my lord,
9.
Yes, tell us.
Yes, Your Lordship. My only ground for objecting this bail is that because Your Lordship is aware that even if there is a love affair, if it appears that the victim is a minor, then this contention that there was a love affair between the victim and the accused, it holds no standing. Your Lordship, it may go for, since it's already a trial, the PWs may be examined at this point of time. I think Your Lordship.
I think,
Victim was yet to be examined, last, updated status was called for, but I have not gone through that part. Total 7 witnesses in the charge sheet. Team is very much necessary, victim and informant.
What happened on 6th?
Sorry, my lord.
What happened on 6th? No information.
Alert fixed for production of accused.
They were not appearing, my lord.
informant and the victim.
No, no, not gonna make you. You get in. Six.
Okay, we'll get you.
But on 6, this is fixed for production of accused. Again, it is fixed on 28th of 2012 for production public evidence.
On 6th of the evidence not recorded.
No, no, my lord.
As per this note, it was fixed on 6th of 12 for evidence. On 6th, whether you are having the order?
No, not, order is not, my lord. Only information. Order to no.
You're in custody since when?
I've been custody since my lord
27/3.
27/3, my lord. 2024.
Heard Mr. Rasdas counsel appearing to the petitioner. Mr. K.K. Parakh, Kitchen Public Prosecutor of the state. Also heard Ms. M.K. Brown, learned amicus curiae for the informant respondent number 2. Petitioner is a asserted accused in Polton Mother accused in session special case number 130/2024 arising out of Polton Mother Police Station case number 105/2024 under section 276(3) IPC and reviewed section 6 of the PSUS Act 2012. The petitioner was arrested on 27/03/2024 and in custody since then. Hence this. Okay. 27/03/2024 in custody since then. Hence this bill application by deputy. The record of the case was called for by order at the 03/06/2024. It is also seen that minor victim girl in the event where gave birth to baby and on the prayer of the concerned investigating officer of the case, the learned special judge Foxo Kamruk Metro Guwahati allowed the said investigating officer to obtain blood sample of the petitioner for the DNA test of the child born to the victim minor girl. Mr. Parashar, learned additional public prosecutor and instructions submitted in that the DNA test result when received from the forensic laboratory and that the concerned IO shall place it before the learned special judge. So on the next that fixed. The inside special case, special session special case number 1302 on the next that fixed. It is seen from the case records that evidence of two witnesses, prosecution witnesses have already been recorded. And that next date of the case, 2012-2024. Consider, next slide. Ms. Brown, learned amicus curiae appearing for the informant respondent number 2 submitted. And that the victim was a minor of 16 years when the incident occurred. And submission. The petitioner submitted that it was a conscious act between the petitioner and the victim. That since the victim was a minor at the time of the incident, 16 years old, our consent is immaterial. Whereas the petitioner, the accused petitioner, was major. Considering such matters, the case record on hearing of the submission of the court, the court is not inclined to grant bail to the petitioner, considering his detention in such and such arising out of since 2702. This the Guwahati High Court Legal Services shall pay the remuneration to Miss Monica Karen Brown. Who assisted.
আনিলে ডিএনএ যোৱাকালি পাইছে কৰিছে এপ্লিকেশ্যন আছিলে ভিতৰত নাই এই সাবসিকুৱেন্ট এটা সাবসিড দিব বুলি কৈছে অহাকালি পৰহি জমা দিম বুলি কৈছে কিন্তু কোৰ্টে ৰাখি থৈ দিছিলে মই ওৱান আৰু টু ইভিডেন্স 27, 23rd, 48. Do you have the CS number? Dixit Google. Okay, may I proceed? 261224. And it is 412.
23rd of January. Item number 22. Mr. Sharma, do you have the case diary with you? নাম টাম চিনি পাম। Petitioner namely Sachin is an FIR named accused in connection with Manipur police station case number 125/2024 under sections 75/115 within bracket 2/64 PNS related section 6 of the PSUS Act. And was arrested 10/09/2024 full stop. He was also produced before the London Special Judge Oxo Bongaigaon. Special Judge Bongaigaon on 10/09/2024 itself. By this application, certain petitioner reported the money for PSS. You are appearing? Mr. B. Sharma, an additional public prosecutor, submitted that the case there is available with him, and as per instruction, police is yet to submit / file search it inside money could be a case number. Since 10/09/2024 till date, the petitioner is in custody for more than 92 days. Already completed appear before the eye. Every Thursday for the next week, English calendar month during official holiday or till the date of filing of the search certificate, whichever is that. But the condition. Okay. Yes, Mr. Sharma. You have the case diary. Day after tomorrow. On the prayer of percentage list on 13.
Your Lordship, accused petitioner is 452 days in custody, in judicial custody, and it's more than 1 year since the charge sheet has been filed, Your Lordship. But trial has not commenced, charge is not taken. He's been kept in that custodial condition for a very long time, Your Lordship.
Mr. Sharma, what do you have to say?
Here, Lordship, if I may submit, Lordship, did
What
task-
happened on third last yesterday, day before yesterday, the matter was fixed on third. What happened on third?
Third, the Honorable District and Session Judge was not there, Your Lordship. And it's been happening for the last 1 year, Your Lordship. Either the judge is on leave or he's not being taken charge. And similarly, Your Lordship, for more than 1 year, the charge sheet is pending. No charge has been taken. Whether he is guilty or not has not been proven, but he has been sent to custody. Again, 1612 is fixed for remand, Your Lordship.
We'll take up this matter on 16th. Make a mention in the morning on 16th.
16.
To chamber.
I'm seeking an adjournment in this matter today, maybe listed sometime after the vacation. We need
Yeah.
some document from
Lordship,
started matter.
I have an objection, Lordship. Lordship, I have an objection to the prayer of the petitioner, Lordship.
But
Lordship,
he's in-
because, Lordship,
he's
there is
in jail.
nothing, Lordship.
He's in jail.
Yes, Lordship.
It's
It is bail.
3-8, my lord. 8-3. I'm in detention, my lord. We need some document from the lower court charge sheet and matter, maybe listed after.
This is not a
vacation,
case
my
for
lord.
bail, Lordship. That is my prayer, Lordship, because section.
He's not seeking bail today. He's seeking an adjournment after being vacated.
My lord.
23rd.
Lordship, at the outset, I should tell your Lordship indulgence. Just so matter.
Yes, notice served.
Yes, yes, Lordship, the name is shown, Lordship, TU law score correspondent number 2 in the cause list, Lordship.
Please take your seat. We'll come back to you. Please take your seat.
Lordship.
No.
Notice issue.
Mr. Sharma, what do you have to say? But since the counsel for the informant did not appear,
Lordship.
we have to engage myself.
Yes, Lordship, otherwise his name is shown.
Name is shown, he has not appeared, that's the thing.
It will come up on next week, Lordship. No. Yes. Lordship has taken note of the official report, Lordship.
No, not yet.
Yes. It is dated 14/3/24.
The name of the counsel for the informant will reflected in the broadcast. None appeared. Or the informant opposite party number to remain unrepresented when the matter was taken up for consideration. MS Monica Karen Brown. Be appointed. 16th copy of the she may be allowed to go to the case records. Intermediate. 16. Mr. Hooda will have it on Monday 16th because the counsel for the opposite party is absent today. So we need to have the amicus will appear on 16th. So we'll consider your bail prayer on 16th. For Mr. Hooda.
My lord, FSL is not yet received, my lord. Today is 53 days. May I pay for my lord, only 17, my lord.
The application hearing is admittedly a consumer, your lordship.
On 17th.
17, my lord.
May I please, your lord. 85 days is in custody. And in fact, Doctor will kindly see that nothing has been seized from the possession of this present petitioner. Doctor will find the FIR in page 1, annexure 1, page 16.
Yes. FSL received, my lord.
So receipt. PD was called for lordship.
PD available, FSL, just today morning FSL received, my lord.
FSL will perhaps not be pertinent so far this present petitioner is concerned, because nothing has been seized from their concern. They have been arrested, they have been arrested, lordship, on the ground that these petitioners were in connection with the main accused, from whom they have, the contraband has been seized. Now, if your lordship looks into the forwarding, lordship will kindly see that there the name of two persons, Pavitra Khudal and Dipankar Das, is mentioned, lordship. From these two persons only, the contraband has been seized, and nothing has been seized from my present petitioner. I would pray, lordship, since 85 days already in custody and nothing has been seized from their possession. Already the contraband has been seized from somebody else. Therefore, on any condition, lordship, I may be allowed to go on bail, lordship. Nothing has been seized from us. Only ground on which we have been arrested is this, that we are in connection with the main accused. That is the only allegation. And no, there is no section 29 also in the FIR, lordship. And so far our instruction goes, I don't know what is in the case diary. There is no call reports also to present them on the ground that there was a constant phone call along with this petition. Okay, may kindly have a look into the case diary, what is the allegation against that? We have to explain it.
But there with Dipankar, my lord, they have, my lord. Yes.
May kindly have a look into page 39.
Rizabul Aru, Rajibul Islam.
Page 39, lordship will kindly see that the name of the accused are different. It is one Pinath Mondal and Samendra Sarkar. Suspected ganja from the vehicle of the accused Pinath Mondal and Samendra Sarkar. This is Annexure 9, page 38. It is the order by which the bail petition of the present petition was rejected by the court. 22/10/2024. And it is from the city only. From the present petition alone. My lord, one thing is that, my lord, though FSL received today, only today we have received the FSL. CD was not taken back. CD is up to, my lord, 2110. It is not updated, my lord. I need, my lord, regarding there, my lord, one updated. Necessary. Only one note of the last note of the I of 1511 regarding the FSL not received. Now today morning only FSL we have received, my lord, is positive for cannabis. FSL not pertinent so far we are. Regarding, my lord, subsequently, my Where lord, is your forwarding? investigation is progress. That is, So, my lord, forwarding lordship will kindly find in annexure 4 lordship, page now 26 18. and 27. Yes, person be case date. यहाँ पर की या सही तो अभी तक नहीं लगा मत তারপর তিনটা মোবাইল সুইচ করতে মোটর করে কানেকশন
Yes, Mr. Parashar, what do you have to say? Who accused indicated whom? Who accused indicated whom? What Mr. Hochaji, counsel appearing for the petition. And Mr. K. Parashar, an additional public prosecutor appearing for this petition as namely for a petition as namely for a which they were arrested on 16/9/2024 and in custody since. As for the affair of the case dated 14/09/2024, during Naka checking, a vehicle bearing registration number AS01EM 616 coming from Halikpur side towards Balipura was intercepted in and around Bubula Gaon. Though the said car initially tried to flee away, but police seeing police checking, but police personnel from Procedural police station could apprehend the said vehicle. And two persons, namely Pavitra Kudal and Sirajuli Malia Ali, were apprehended. During search of the said vehicle, in presence of independent witnesses, with due authorization, 29 numbers of white color polythene bag containing some leafy materials suspected to be ganja were recovered from the said vehicle. On weighing the suspected, when weighing those 29 packets suspected to be NDPS in bracket 152 kg, 152.720 kg could be recovered, which were accordingly seized in presence of independent witnesses. Both Trinath Wonder and Samaran, both said Satanam Pavitra Kudal and Dipankar, sorry, I don't know the name Dipankar Kudal, Pavitra Kudal and Dipankar were arrested. And they were produced before the Lana Chief Judicial Magistrate Tejpur, Sonitpur, Tezpur on 14/9/2002. It is submitted by the petitioners, though they were arrested on such and such on 16/9/2024 inside Solidor PS case number 154/2024 under section such and such. It is stated neither they were FIR and accused nor involved in such criminal case, and that they have been falsely implicated. During the deliberation of the matter, as such, Mr. Protector Counsel appearing to the petition is submitted that petitioners should be considered for their bail, considering the detention since such and such inside. Mr. Parashar, an additional public prosecutor, placed the case there relating certificate press case number such and such, along with the FSL report of the seized and the seized suspected anti-paint items relating to said Solidor PS case. The FSL report dated 09/12/2024 indicates that the seized items in such and such confirmed to be cannabis, indicated under the Civil NDPS Act. Though petitioners are not FIR accused, case diary indicates sufficient incriminating materials against the petitioner number one with regard to his involvement in that petition number one, such and such and such. Considering this such and such bill rejected. However, from the case there is no such and such material could be found against the petition number 2 and 3, namely. All right. Further custody condition that the 40 to local city. To appear before the IO every Thursday, commencing from 19th for the next 3 release calendar month or till date of the filing of the charge sheet in the case, whichever is early return ticket. Mr. Parashar, 2 and 3 allowed, 1 rejected. Return the case.
The service of notice, Lordship, it is complete, Lordship.
May it please your lordship. This is a regular bail application, lordship. We are 71 days in jail custody, lordship. Just a minute.
Here petitioner is 22 years old and the victim lordships are 15 years old lordship. Now lordship, FIR lordship will find on page 15 lordship. They have a love relation lordship, suddenly broke down lordship, then this petitioner was get arrested lordship. And he has moved bail before the court below lordship, the informant side appear lordship, they are told they have no objection if bail is granted lordship. Now lordship, since they are in relation lordship, here also lordship have annexed an affidavit lordship, xerox copy. That is on page 22 lordship, relevant portion on page 20. Consensual lordship, relation lordship. The girl wants him to marry lordship, the boy say you are minor, that's why lordship. The marriage was not held lordship.
You have the case diary?
Yes, Lordship. Lordship, the 164 and 161 Lordship is consistent Lordship. And apparently she is a minor Lordship, 15 years.
Yeah, about this too. Your case number. About the person.
Bail rejection order that is court below lordship, that is on page 20 lordship. This petitioner lordship 71 days in care custody lordship, he got that by SN lordship.
W. Medical is not available.
Lordship, medical is not there. Lordship. It has not been received. Lordship.
Yes, for the.
Lordship, and the informant, Lordship, I received the notice, my lord, I appeared, my lord. So informant make an affidavit, my lord. That
That I have made.
the original one.
Heard Mr. B. Chaudhary, learned as counsel appearing for the petition. And Mr. K. K. Parasar, learned, sorry, Mr. B. Sharma, learned additional public prosecutor appearing for the state. Also heard Mr.
F.A. Hassan.
Your name has not been there. When did you
My
appear?
lord, today we have filed the call of law, my lord. They come, my lord, they're sitting outside the court, my lord.
Appear, say, learned counsel for the informant respondent. Number 2. The petitioner was arrested on till 01/10/2024 and in custody. As for the affair of the case dated 29/08/2024, logged before the Subenda Police, Nalbari, by the informant, harassment number 2, opposite party number, is that on 21/08/2024, when his minor daughter, aged about 15 years, was returning home from her school, the petitioner induced her offering his love and affection to her and took her to a nearby jute field where the petitioner committed rape on her in spite of her resistance and objection, and threatened her that if she reveals about the said incident to others, she has to face dire consequences. Initially, fearing of her life, the victim did not inform her parents, but on 29/08/2024, as she revealed about the said incident to her parents, the informant, my father of the victim, have submitted the written application before him. nothing such. Open the police. The said written complaint was forwarded and accordingly. Mokalma Police Station. Case number such and such. The petitioner was taken into custody on 1/10/2024 and was produced before the special judge Boxer Nagpur. Here is the case they placed before the court on next. Mr. Chaudhary Leonard Counsel appearing for the petitioner submitted in that the petitioner and the victim girl had love affair and he has been falsely implicated in the case. Mr. Unliquid Leonard Counsel appearing for the informant opposite party number 2 submitted that the informant doesn't have any objection if the petitioner is released on bail, as in the meanwhile. But the informant as well as families of the victim, the families of the petitioner have compromised the issue outside the court. It is also stated that in that regard, the informant on zero 4/11/2024 sworn an affidavit before the notary public at Baksa at Musalpur, Baksa village, Musalpur district, Baksa. Mr. Thermal and additional public prosecutor have placed that from the case there is submission. The submission that the statement of the victim recorded under section 133 BNS as well as her statement made before police under section 180 BNS found to be in which she has implicated the petition with regard to the alleged crime. Here is the case that he placed before the court, and it is seen that the police have already seized the birth certificate of the victim girl, which indicates her date of birth as first of January 2009. As such, on the date of the incident, 21/08/2024, the victim was a minor girl of 15 years, 7 months. On the other hand, the petitioner is found to be 22 years. From the case there, it is also said that in a statement made before the learned Judicial Magistrate First Class Nalbari on 30/08/2024. She indicated that the accused petition forcefully, in spite of her resistance and objection, committed rape on her. From the case there, it is also seen that the accused petitioner used to stalk her whenever she is to go to school or return from her school. When the said incident was reported to her parents by the victim, the parents informed the mother as well as father of the petitioner not to disturb the victim girl. And in spite of that, it is seen that the petitioner continued to stop the return the
Should reject it at this stage.
Not at this stage. If we allow this condition, then what will happen to the society? Whether he is 19, 22, this cannot be a ground that father will come, that they will marry, we have compromised.
Lordship, young boy, Lordship, in
Maybe
relation, they have
after
not,
18, nothing doing.
that part they have not learned, Lordship, now
Whatever.
71 days, Lordship, that's why, Lordship.
Mr. Chaudhary, certain things are there. You have to follow a decorum inside the court, even outside. Right, in the, even the society needs. Otherwise, it will be uncontrollable society. Nice. That's why the law is there. To control such people.
May I please your lordship? Lordship, this is a regular bail application. The FIR starts from page number 12. What has happened in this case is this, lordship, the accused person, while working as a Borababu of the Kamalpur circle officer in the office of Kamalpur circle office, lordship, that informant was demanded with him bribe money. While he was accepting that bribe money, the accused person was arrested by the officers of the Vigilance and Corruption Cell, Assam Police. Lordship, without going into the merits of this case, Lordship, in 2 points, I will sum up my argument, Lordship. Firstly, Lordship, the accused person, Lordship, he is a patient of lumbar canal stenosis, for which, Lordship, he had to undergo implantations, Lordship, in his spinal cord. Lordship, at page number 25.
Mr. Sharma.
Yes, Lordship.
In the reading of page 20 and 21,
Lordship.
what do you have to say? Was there any practice?
Yes,
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 yes.
Lordship. I'm behind the bars for 42 days, Lordship. Otherwise, Lordship, all aspects of investigation is complete.
Where is
My custodial detention, Lordship, may not be required, Lordship. I am placed under suspension, Lordship. I have lost all my reputation, Lordship, and besides, Lordship, I am a medical patient and I need some medical attention, Lordship.
there is no mention of any practice in the FIR? Or it is there?
The FIR, Lordship, yes, it is there.
Where is the remand? You have not made the remand one. Not, you have not annexed the remand order. It should have been in the remand order.
Everything is there, Lordship. The trap case, Lordship, independent witnesses are there, demonstrator witnesses there.
Video, audio recording was also there, Lordship.
Yes, only the CDR analysis report, Lordship, that has not been received. The audio transcript, I have flag mark, Lordship.
When the bribe money, everything is seized, Lordship.
Itu bisa dikirim ke perubahan. Ini tekstur apa? Mau terus kerja beli. Betul. Iman ada orang yang ikut cerita. Bolong.
Mr. P.P. Mehdi, Land Council appearing for the petitioner. And Mr. B. Sharma, Director of the Prosecutor, appearing for the state.
Page for the medical patient.
Person to a complaint, there is 28/10/2024 law before the Superintendent of Police of Anti-Corruption wing of the government of Assam. Anti-corruption role. ACB case number 78/2024 was registered in and during a trap case, he was found involved in the corruption charge in presence of independent. Accordingly, he was arrested and later produced for the London Special Judge Assam. On 30/10/2024. And since then, it was 1-2. It was produced for assessments 01/03/2022, which is then in custody. 29, not on 30, was produced before the assessment. on 29/10/2024 and since then in custody. Petitioner is the Borobabu Wooden Bracket Head Clerk in the office of the
Circle Officer, Kamalpur, Lordship.
Circle Officer,
Kamalpur.
Kamalpur, District Kamrup. And from the complainant, he asked for certain bribe money so as to record his name, to insert his name in the land records with regard to landed property left by his father by way of right of inheritance, to which his other brothers submitted that it doesn't have any objection in that regard. Considering his detention since 29/10/2024, petitioner has paid for his bail in the NDPS case. No, that's it. Here is the case there. Here is before the court by Mr. P. Sharma. Yes. It's found that police have taken the petitioner in custody and practice and everything has been seized. Following the due procedure in presence of independent. Considering the materials in the case, and since all the relevant materials have been seized in the case, the court is of the view that further custody detention of the petitioner is not warranted for investigation of SAVPS custody. 50,000 to local civil, one of which shall be a government employee. Appear before the concerned investigating officer of SABPS case number. Every alternate Thursday for the next 3 English calendar months commencing from 16/12/2024, sorry, 19/12/2024, and for as and when he is required for necessary investigation. Lucky condition. Says not likely to be written the case. Is appearing. Yes, what do you have to say? Please come this way. We have seen,
That's seen the postmortem also.
we have seen here. We have the records. Yes, please come this side. Ask her to say something. Oh.
Lordship, respondent number 2 has adduced our evidence and both sieve and cross, so bail consideration depends upon you, Lordship. Cross and sieve and cross.
EW1 goes to show that it is a newly planted case against the petitioner.
The Lordship kindly goes to the medical, Lordship is in the medical.
नाम to record करो. Third, Mr. M. U. Mandal, counsel appearing for the petition. And Mr. B. Sharma, additional public prosecutor, Pratham for this state. Also heard such and such. Learned counsel appearing for the informant. Opposite party number 2. By the petition. Arising out of POCSO case number 257 of the 2024. Arising out of Delhi police station case number 24 of the 2024. The 6 sequence like it charge corresponding to the number 78 of the 2024. In which he was arrested on 24/04/2024 in custody since then. Okay. We have to rise. There is a meeting at 4 o'clock. Petition rejected.
I will.